Hi, everyone. I see you guys starting to log on. So thanks for joining us today. We're going to give everyone just one more minute to get signed on and get started. All right, and I think we can kick it off for the sake of time. There's a lot to cover today. So just some quick cleanup. My name is Cecilia Mortar, and I am the programs manager for the Steamboat Springs Chamber. I want to thank all of you guys for joining us today, and I also want to thank our generous sponsors for the business education series, the Employers Council, Northwest Data Services, and Mountain Valley Bank. They make these possible. So we really appreciate them. And I would also like to introduce our speaker today, Tina Harkness. Tina is an employment law attorney and general counsel at the Employers Council, an employers association that supports employers in Colorado for over 80 years. We're extremely lucky to have them. They have 200 HR and legal professionals that are ready to connect you with the services, resources, and training opportunities that your business may need. So please consider them as an asset to our community. If you have any questions, as I said, we have a lot to cover, so I will let Tina take it from here. Thank you, Tina.
Thanks, Cece. Hello, everybody. I hope you're having a good day so far and a good week so far. I'm going to be sharing some slides with you today. It seems like summer has just flown. I don't know about for you guys, but for me, it has, because we were here in May talking about employment law updates. So somebody give me a thumbs up or an okay that says you see my slides without my notes. If you're seeing slides with notes, sorry?
We see your slides without your notes.
All right, beautiful. Thank you, Cece. So I don't have many notes, but I need some because things are constantly changing and I want to give you the latest and greatest of where we are COVID wise, monkeypox wise, since that wasn't in our May update, and follow up on some of the Colorado laws that we spoke about last time. I've got some information to give you there. And then what we're seeing coming down from the federal agencies that may affect your businesses. And we'll talk a little bit about overturn of Roe v. Wade and impacts there. And then inflation, right? That's the other big news that we've been struggling with for some time as businesses. So we'll start with COVID. I had this in the last session, but just a reminder, we are predicting another surge. This will be what, the 7th, I think. So we do have some other changes that are going to make a new surge different in our businesses. Just what I added here, and I heard this morning that new Omicron specific booster is going to be out even this coming month in September. So hopefully that will help give people some protections from these more catchy Omicron-based variants of COVID. So this is some updates on COVID that we didn't have in May. Again, this is changing. COVID's changing, right? It's becoming, I don't think we're at the endemic stage. I think we're still pandemic stage, but this is some indication that we're maybe normalizing, if that's the right way to say it, COVID in our workplaces. So the EEOC, so that's our federal civil rights watchdog, the Equal Employment Opportunity Commission, updated its FAQs on COVID with regard to employee testing. And really since 2020, when the EEOC said that COVID is a direct threat to the health and safety of all humans, they've said testing is something that all employers can do. And some employers have put either mandatory vaccination requirements in place, or they've had that option to do some ongoing testing. And that's been justified as far as the agency is concerned based on that direct threat nature of COVID. But in July, mid-July, the EEOC came out with some changes to that, and they've said that employers to have those ongoing testing requirements now need to be able to make the business case for that. So again, normally outside of COVID, we don't test our employees except in very limited and mostly the healthcare industry. And that's because we have to justify that based on business necessity. The pandemic changed that, but now we're kind of going back to the previous standard where if you're going to require ongoing testing of your employees, you need to be able to show that there is a business case for that. So some things that could go into that business case are things like the level of community transmission, and we know all that data is available to us. Vaccination status of our employees, if we know it, right? So the degree to which breakthrough infections, right, are possible, even for folks that are up to date on vaccination, right? The transmissibility of the current variants, if they get catchier, which is hard to imagine, but they could, and the possibility of severe illness from a current variant that's in place. Omicron is still deadly, but it's less deadly, fortunately, than previous strains of COVID. So those are things that you would want to factor into your analysis, as well as what kind of work, right, the employee's doing. If they're working with medically vulnerable people, that's going to make a difference for requiring ongoing testing. So they also added to their FAQs, and this has been in their guidance for a while, that we cannot require antibody tests before employees return to work. And that's really because those antibodies stay in people's bodies for a long time after the medical community feels like it is okay for people to stop isolation or from having COVID. And we can uniformly test applicants. That means for certain positions, or across the board, if that's the case, if it is justified by business necessity, not individuals, like you have to be tested, but not you. That's going to be a problematic situation. And employers can rescind job offers to applicants who test positive and need to be in isolation if that position needs to start immediately and be performed in person. So here's a link to the FAQs and the additional information that the EEOC has put out. Also, in the middle of August, we had an update, hopefully you've seen this, of the CDC's quarantine and isolation guidelines. And they're reducing, right, the amount of time that people have to remain in isolation if they test positive. That's the big news here. So we used to have that 14 days, and then it became 10 days, and now we're down to 5 days. So 5 days of isolation is recommended for anyone who's tested positive for COVID. If they have no symptoms, they can end isolation after 5 days and then mask for an additional 5 days. For the quarantine guidelines, if someone is boosted or has received that first round of vaccination in the last 6 months, there's no quarantine required for an exposure situation if they have no symptoms. The recommendation is to wear a mask for those 10 days following exposure and to test on day 5 after exposure if possible, right? Because it takes a while for somebody to test positive for COVID, we know that. If someone is not boosted or vaccinated in the last 6 months, quarantine is recommended for 5 days after exposure, and then the mask for 5 days. If you cannot quarantine, so this wasn't in there previously, masking for 10 days is possible. And then again, test on day 5 or later. So those may make it easier for us when we have folks that are exposed and need to be out, because it's shorter periods of time, or we have other options, so that hopefully we can keep our staff and keep our businesses functioning. So there's some different percentages out there for how many people who have had COVID who may develop long COVID. So long COVID is symptoms of COVID that last 3 months or more. So beyond the 3-month mark after having an active COVID illness. And the stats are pretty jarring, right? I just put one of them in here, 1 in 5 adults. So when you think about almost 90 million people having had COVID, that's a lot. 1 in 5 of those individuals maybe having long COVID is quite a few. So this is the CDC's estimate. And of course, long COVID, the symptoms tend to be respiratory, as we could imagine. They could also be that brain fog that, that some people are complaining about. Sometimes I have that even without COVID, but that's a serious piece as an after effect. And then even sleeping problems and other depression, anxiety, dizziness, all those kinds of things. So if you are covered by the Family and Medical Leave Act, so that is private employers that have 50 or more employees, and then it's all public sector employers, then you need to look at if somebody needs to be out longer than the 2 weeks that people have typically been out with COVID or less, then family and medical leave may apply. It's going to depend on your employee's eligibility for that leave and how long they're having trouble with it, but that's something to not forget. And then for all employers, either if you have 1 or more employees, you're covered by Colorado's Anti-Discrimination Act, which requires disability accommodation. If you're at 15 or more employees, you're covered by the Americans with Disabilities Act. So just know that long COVID may be a disability under the ADA or the Colorado Anti-Discrimination Act. And if your employee is having extended difficulty, that you do need to engage in that interactive process to determine if that person with some accommodation can still perform the essential functions of their job. So don't forget that piece of it. For paid leave, we know that hopefully you know by now that the federal public health emergency was extended again, and our new deadline is October 13th of this year. So under the Healthy Families and Workplaces Act in Colorado, all employees of all employers, right, need to be able to use any public health emergency leave that they have left until 4 weeks after the end or the suspension of the public health emergency. So if there are no further extensions, I keep changing the dates on this slide. If there are no further extensions, this leave is set to expire November 10th of this year. And again, I'm going to leave this last bullet on here just to say, watch for further extensions. You've probably heard me say before that this keeps getting extended out really because of all that relief money as well. I mean, the effects of the pandemic, people are still getting sick. People are still getting very sick and dying from the pandemic. I'm not minimizing that. And it's also being extended to keep the money flowing from those relief funds, as there was a substantial, we know, amount of money that was put into our system, and it takes a long time for that to get to where it's supposed to get to. And they want to keep the public health emergency in place until that all gets distributed. I thought this would be interesting for you. This is a Denver Business Journal article on the Healthy Families and Workplaces Act enforcement since it went into effect. And the CDLE is the Colorado Department of Labor and Employment. So they are charged with enforcing the Healthy Families and Workplaces Act, and they've been putting out guidance and all of that all along. And they just, they've gotten 743 complaints. A lot of them have been resolved without any action on their part when they get in touch with the employer and inform them, of what their obligations might be. and what they need to do differently. They have ordered wages to be paid, back wages to be paid that weren't paid by employers in about $170,000 worth. And then they have assessed 1.16 million in fines. Now, most of that, 887,000 of that, so a lion's share of that, was against Southwest Airlines. So you probably saw that in the news that they went after Southwest for not providing Healthy Families and Workplace Act notice and time off to its employees, and they're in litigation. Southwest, of course, sued the state and for the fine, and they're trying to say that they're a federal transportation agency and they are unionized and they have collective bargaining agreements with their unions for how much paid time off they provide, and that should supersede the different rule that Colorado has. So most of that is the Southwest case, but the complaints have been focused on failing to provide the notice. So do make sure you have that poster up, either electronic on your intranet and or physically in your workplace if you have people coming in physically to work. And then the other big area of complaints was denial of leave. And in the school year, denial of leave to take care of sick kiddos. So like I said, most of the complaints have been withdrawn because employers have quickly corrected the issue, but they have issued 88 citations, and the average fine has been $1,000. So there's some enforcement going on here, but not, if we're doing most of this stuff right, we should be okay. The CDLE has also updated its Info 6B. So the infos are their guidance. It's not the statute. It's not even the rules that they have to go through rulemaking for. These are guidance documents that they can update at any time without notice and comment to employers. But they have clarified a couple things as of end of June. So one is the whole carryover piece. So I put this example in there because there was a lot of confusion about what is this, if the threshold is 48 hours in a year and the carryover is 48 hours in a year, what happens does the carryover reduce what the employee earns or is granted or accrues in the subsequent year? And the answer to that is yes. And we've been fortunately telling you yes for some time. So this gives an example of a situation where an employee earns the 48 hours in a benefit year, carries over 40 of those hours, and then the employee, because they carried over 40, can only earn an additional 8. That's assuming you max out at 48. If you've set your threshold higher to do more than the law requires you to do, then they could earn more up to your limit. But this makes clear that that rollover does affect the accrual in the next year. And this one's a tougher one. So the other confusing part about Healthy Families has been this credit that you can get for sick leave against the public health emergency leave. And since fall of 2020, prior to the law taking effect, January 1st of 2021, we've been clear that at the date the public health emergency is declared and the date the law takes effect, 1/1/21, that's when you needed to allot the public health emergency leave. And then there was guidance that came out after that about new employees that you needed to allot the public health emergency leave when they started. Well, they've tinkered with that a little bit in their latest guidance. And I've highlighted in yellow that language where they tinker with it. So they're saying during the public health emergency, the supplement occurs at the time of the request. So this is tricky, right? Because you've already done it in most cases, right? Without the request at either that 1/1/21 point when the law took effect or when someone started. So what's the impact here? If you gave the supplement when someone on 1/1/21 and they got less than a full 80, say they were a full-time employee, and they didn't request any leave. And now they request that leave, and their accrued leave is the amount that you're trying to credit, right, towards the supplement is less than what they had at the time of your original allotment, that there's a difference there. So say January 1, 2021, they had 40 hours of leave already. So you gave them 40 supplemental hours, but they never requested any public health emergency leave. And now in August or September 2022, they finally request that leave, and they only have 20 hours of leave banked. So this would imply that they get 60 instead of that 40. So it is a pickle. And this is guidance that, again, is not part of the rule or not part of the statute, but it is going to be how the Colorado Department of Labor and Employment is going to enforce this law. So if you are running into situations like that, you may want to relook at your allotment for public health emergency leave for your employees based on this most recent, from the end of June, guidance from the Colorado Department of Labor and Employment. And I'm sorry for that confusion there. We can only rely on the information we have at the time. So this is new. So monkeypox, we've been getting a lot of questions. Do employers have to provide a new allotment of public health emergency leave for monkeypox? And the answer is no, even though monkeypox has been declared as a public health emergency federally earlier this month. The Colorado Department of Labor and Employment has said it's not novel, and it's not at this point highly fatal for the people who get it. So it's not meeting the Colorado Healthy Families and Workplace Act requirements to trigger a new allotment of public health emergency leave. So that is up on the Department of Labor's website for Colorado at this link, and we'll be tracking that to see if that changes. But compared to COVID, as far as contagiousness and fatality, monkeypox has not, fortunately, been as serious or as prevalent to this point. So we did have the leak of the Supreme Court's opinion overturning Roe v. Wade, and then finally had the publishing of that opinion in June. So the immediate impacts of this are to employer benefit plans. So you're probably already looking at this if you are in process. But if you have a fully insured plan with a carrier, you know, the coverage of abortion services is going to depend on state insurance law. And we know in Colorado that we have a law that legalizes abortion in this state. So if you are functioning here, you're insured in this state, then that can continue if you have those abortion services covered under your plan. If you are outside of Colorado, then it's going to be dependent on that state's insurance law. Self-insured plans. So if you're covering some of the cost of your health plan, generally you can choose what is covered under your plan, unless there's some statute that criminalizes that. So we do have to be aware there are some states that are prohibiting aiding and abetting abortions, and we don't really know how far that aiding and abetting will extend. So if you're in states, I know Oklahoma and Texas are a couple of them, but it seems like there's more every day that are passing some additional laws here. So it's important to keep that in mind. So you want to review your plans to determine coverage. If you don't already provide travel related benefits for medical services that aren't available locally, many plans do, then you might consider whether you're going to do that and make a decision. Every organization is going to decide that for themselves, and you may need to rewrite your plan. There are other benefits that some employers are providing outside of their health plan, such as relief funds to pay expenses for employees who have to travel for reproductive health care, and one-time bonuses for travel. I've also seen articles about that. So that's the immediate impact, and we'll see what additional impacts sort of come down the pike on the overturn of Roe v. Wade. Federal rules, let's see. Independent contractor rule. So these are the people who you pay as workers for you, but they're not employees. And this rule has been the subject of some controversy in Colorado and some litigation as recently as 2015. It's also a political football federally, that whenever the administrations change from one party to the other, they change this test. So if you feel like, we've talked about this a lot, if you feel like there's a little bit of whiplash about what is the test for independent contractor status, you're right. There has been all of that. So right now, the test is called the economic realities test. And this is at the federal level. There are additional state tests, but at the federal level, which is kind of our overarching, and then the state can get more narrow if it wishes to, we're using an economic realities test. And this comes from the Republican Trump administration. Biden administration tried to roll it back at the very beginning, but it was reinstated by a federal court because they didn't do that correctly. They are in process to change this rule. And they did focus groups in June of this year with businesses, and they're mainly focused right on the gig worker issue with Uber and Lyft and all of these other companies that are using gig workers. They tend to be classified as independent contractors, and some of them have sued, right, to be classified as employees because they want the different protections and benefits that come with being an employee. While there's this tension where a lot of gig workers want to be gig workers, they don't want to be employees, they want to be independent contractors. So we've had this in the news. So the current economic realities test really focuses on those two criteria that are also the main criteria in Colorado, which is the control that the business exercises over the worker, right? The more control, the more likely it is to be an employment relationship. And then the worker's engagement in its independent business. So the worker has to have kind of a going concern separate from your business. So they're holding themselves out to the public. They're doing work for others. If not sequentially to the work for you, they're doing that after you and before you, that they really have that opportunity for profit or loss from the work that they do. Whereas if employees don't do their job well, they still get paid. There might be some performance management. They might ultimately be separated from employment, but we don't not pay them if they don't perform correctly. Whereas that can happen in an independent contractor situation. So those are the two main criteria, and that's federally. The test that we're probably moving towards is called the ABC test. So that just means there's 3 criteria instead of 2. And California has been using this for some time. And that would add that the worker has to perform work outside of the usual course of the hiring entity's business. So some of this gig worker stuff, is within the scope of the hiring entity's business, right? It's almost overflow work that we don't have enough employees to do. Sometimes employers, instead of hiring temporary employees, will get a gig worker in to do similar work to what their employees do. Now, that's always been a dangerous tactic from an independent contractor perspective. That's been something that has been looked at and in the balancing test of, is this worker, a contractor or an employee, but that will now be part of the test. So it will be part of that evaluation. Of course, Colorado's test must also be considered. If we do go to this ABC test federally, arguably the federal test will be tougher than the Colorado test. And hopefully you are aware that Colorado has some of the toughest penalties of any state for misclassification of independent contractors. So in addition to back pay, if that person should have been an employee instead of a independent contractor, and overtime if they should have been a non-exempt employee, there are additional penalties under Colorado's law. The minimum penalty is $5,000 per violation, and it can escalate for subsequent violations up to $25,000. So it's significant. You don't want to make this decision lightly or without adequate consideration. Also, the overtime threshold is going to rise. So there's a minimum salary level that's required under the federal law and now under Colorado's law for private employers to keep someone classified as an exempt employee. So exempt means they're not eligible for overtime. So it's not, the salary level is not the only test, but it's one of the tests. So if you flunk this test, then you cannot have that employee exempt from overtime. They do need to be a non-exempt employee, eligible to receive premium payments and recording their time and all the other good stuff that comes with being a non-exempt person. So the current federal requirement is $684 per week. That was changed in 2017. The Colorado requirement for private employers, so that's most of you on this call. It's everybody except government employers, special districts, right? Public sector folks. You are higher, and you've been higher than the federal level for some time. And we have a step-up process that's I just put on this slide so you can see where it's changing each year for you. You're going to be paying the higher amount, the federal or the state requirement, depending on if you're subject to both requirements. And you might remember from 2016, those of you who were in HR at that time, that they were the Department of Labor was trying to raise the salary threshold to $921 a week, which would have been almost $48,000 for the year. And there was a court ruling that stopped it from taking effect, like literally the week prior to when it was supposed to take effect. So a lot of you had already evaluated, who do we have to change? And some of you had already changed people to either move their pay up or to reclassify their positions as non-exempt. And then that all stopped. And the Trump administration, when it came in, rescinded the whole process after the court decision to enjoin it. So what are they going to do this time? Well, of course, we don't know. We don't have a crystal ball, but many experts think that the DOL will set the new salary threshold around $800 a week. So that will be an increase for the public sector, right, of a pretty good chunk, up to about almost $42,000 a year for your workers. For private, you're already going to be above that. You're above that now, and you will be even farther above that coming up here in 2023. So you're planning for the Colorado requirement to go up, not so much the federal requirement to go up. So for the Colorado laws, we went over these in the May session, and they hadn't yet been signed by the governor because that was really just a couple of weeks after the legislative session had ended. So these have all been signed. These were all the ones that I checked back that we had discussed last time with their effective dates. So everything is also in effect at this point. And what I didn't have in May was the new workers' compensation poster. So it's linked here. So the change on that poster is that employees have 10 days to report an injury under Colorado's workers' compensation statute rather than 4 days. So that's why your poster has to change, because that timeline is different. So do you want to make sure that if you are a real stickler as an employer for an employee reporting within the statutory time frame, that you know of that change from 4 days to 10 days, and that you're not taking any disciplinary action against an employee until the 11th or more day when they have failed to report. I also didn't have the unemployment notice of benefits availability in May, and I still don't have it because they haven't put it out yet. So we have put together a sample at Employers Council that we believe meets all the requirements from the statute. We're continuing to watch for the Division of Unemployment to put out their sample, and we will let members know when that comes out. But for now, please use our sample. And if you don't have that, please let me know and I'll get it to you. Family, I know you've been connected to the state webinars on family, and that is your best resource for updates on family. So I just want to give you a little bit of information here and try not to cover old ground. So just a little bit of a refresh, right? Family applies to all employers who have employees in Colorado. So that's an extensive requirement, and it's 12 weeks and up to four additional weeks for pregnancy or birth complications of job protected leave. And some of the refinements we've seen are in these next pieces. Workers are eligible after they earn $2,500 from one or more Colorado employers, not just from one employer, over 4 quarters. So this isn't a very high threshold for workers to be eligible. So it's not like unemployment where they got to earn that from you, right? For you to be chargeable, they have to earn that from any employer or combination of employers over 4 quarters. Also in May, there was a lawsuit challenging, right, the constitutionality of family as a tax, and that was rejected. That was rejected at the trial court level, and then they skipped the appeals process and went right up to the Colorado Supreme Court, and the Colorado Supreme Court said, no, it's not unconstitutional. It can go into effect at the end of June. So that challenge, if you had heard about it from Kronos Builders, was rejected. So contributions are set to begin, and there's some pieces there that I'll talk about on the next slide, and then benefits will begin in 2024. So local governments may opt out entirely or may opt out of just paying employer portion. And we're starting to see, right, the information of who is opting out. And I think there are about 20 that I've seen that are opting out or have had their votes. So that governing body has to vote by the end of 2022, and you have to notify the family division and employees that you're opting out of the program entirely, or just paying the employer portion of that program. And then for I know a lot of you are smaller businesses, you probably heard this, employers with 9 or fewer employees, you're exempt from paying the employer portion, but you do need to collect and remit the employee portion. And they have said from the beginning, and in the statute is this opt-out process if you purchase or insurance for the same or better leave program, but the state is not set up for that yet. They're not set up to evaluate that yet. So the latest thing I heard is that all employers, right, unless you're completely opted out, have to begin paying premiums, even though you're going to have your own plan. You're going to have to pay your premiums beginning January 1, 2023. And then when the state is able to approve your program, you'll get a refund by January 1 of 2024. So that's not great news that you're going to have to set up your plan and maybe start paying for your plan and pay the state and then get money back. But you can still do the private plan. They're just not ready or having capacity to approve those yet. So there is going to be a registration process. Again, it's supposed to be available this fall. I haven't seen it yet. And you're going to want to be ready to collect and remit those premiums, whether it's both the employee and employer portion or just the employer portion. If you're in this, or just the employee portion. excuse me, and then take a look at your handbook policies to see what might need to change for you. Resources that the state has made available are the premium and benefits calculators. You can kind of run some numbers and see what a typical employee might receive out of this program if you wish to. And they do have an extensive number of webinars. They transcribed all the questions in those webinars and put out the answers to those questions. And they're developing other resources. They do have the family poster that they are calling the break room poster. It's pretty minimal, but you do want to get that posted for your employees. Trends. Let's see. So inflation, it's been beating us up for some time. I think it peaked in June at somewhere, I think north of 9%. We're still having very high inflation. Of course, we know we're experiencing it every day at gas pumps and grocery stores and everywhere else. So we've been trying to get the pulse from our members on what they're doing to respond to inflation. We always do our planning packet every year, and that's about to come out in September. So we will have updated data soon on what the average pay increase our members are providing to their employees for the upcoming year. And that's usually, again, as we get into most employers' budgeting and business planning processes in the fall. So we will have more updated data soon, but this is from June. So we did ask our members if they're planning to adjust their pay increase budgets to add an additional cost of living increase. And 41% of those employers who responded, we had 600 respondents, 484 of them from Colorado, said that they were planning to adjust that by 1 to 5% or more. But 48% of respondents had no plans to adjust their pay increase budgets for inflation. So we have a good share of employers that are doing that, and also a good share that are not. So I think the difference in between, because that's only 89%, I know that doesn't add up to 100%, were unsure, right? They didn't know what they were going to do. And then the average projected pay increase for typical employees. So we usually have the average for the superstars and the average for the typical employees that we put out in our data to you all. The average is 3.9%. And this is high. So the last time we've seen the average at this level, this high, was 2001. And of course, we were dealing with a pretty bullish economy at that time, whereas now we're dealing with maybe an economy that's in recession or going into recession, depending on which expert you're listening to on whatever day. So that's still not keeping up with record inflation, right? At I think somewhere hovering around 8% now. So other strategies that our members are looking into to deal with inflation, right? Remote work, of course, workers are demanding that these days, not post-pandemic, but where we are in the pandemic. Flexible hours, so those are no cost items. Some employers are not passing along health insurance premiums increases to their employees as a way to cushion that cost. And then others are providing a one-time ad hoc kind of bonus rather than adding to base pay, because ultimately that's cheaper for employers. So we'll see what our planning packet survey shows when it's published in September to see if any of those numbers have changed. But this is higher than it's been in some time. So Cece, how are we doing?
Hi, Dina. We have a couple of questions. So from Dina Fisher for Info 6B CDLE, she quoted part of it saying employers need not provide additional HFWA leave if the employee used all of their PTO leave for non-HFWA reasons.
Yep, that's still true. Yep.
Perfect. Dina, let us know if you need any more clarification on that. And then another question we have is benefits for family begin 1/1/24. How soon can an employee request leave?
Well, 1/1/24. I mean, leave if they need that sooner than 1/1/24, which they might, then that would be under your normal leave policies. It wouldn't be under family. The family leave will take effect when in 1/1/24 when the benefits are able to be paid.
Okay.
It'll be contingent with that.
Perfect. For the rest of you guys, please take a couple minutes to put in any questions you have. We'll wait a little bit and see. An earlier question that I typed in the answer for, I will be sending out the presentation slides and the recording this afternoon, so you guys will have that for reference.
And that's my fault that you don't have them now, because I work on this like up to the moment. I mean, I didn't have anything that came up this week, thankfully, but I have had that before with employment updates for you all. So I keep those close. Cece isn't letting you down at all, and I'll send them to her right after we're done.
No problem, Tina. I think it's fine as long as they just have it after. Okay, so another one, do you know how unlimited PTO works with family?
Well, I think we know that, right, if you've got an unlimited PTO plan, that you are saying that as long as employees get their work done, right, that they can take that time. So we've always had employees that have needed extended leave. So I would think you would handle it under your up top. Sorry, my animal is playing with something here. Apologize. I think you're going to handle it the same way you've handled other extended leave. So if you're subject to FMLA, if they had FMLA, then you were typically paying out their full FMLA under your up top. Or if you were providing leave as an accommodation under the ADA, then you were doing that. Now with family, they're going to get money from a state source. So I believe probably most employers are going to offset what the employee is getting from the state against what you pay, so that you're not providing a windfall. That's what I think that you would do. Another option would be, although I'm not sure that this would be consistent with an unlimited PTO policy, another option would be to tell them that while you're receiving benefits of the state, you don't get the ability to supplement that leave. I think with an up top, what's most consistent with that language that I've seen would be to allow them to supplement up to 100%. So the state family benefits, depending on what the worker makes, could pay them up to 90% of their pay. I think that's where it maxes out at this point, and the current maximum premium that or the benefit payment, they think is going to be like $1,100 a week or something. If your employee is up at that 90, they're only going to be supplementing like 10%. But if they're lower than that, then they'll be supplementing greater. So there's going to be some math involved, which is not my favorite thing. But I think that's what you'll end up doing.
Okay, thank you for that. For family, will it coordinate benefits with STD?
Well, so that is that whole private plan thing. So STD has been what a lot of employers have had to this point to provide some wage replacement benefits for extended leave. So I think you're going to want to look at your STD plans pre-family to figure out what you're going to do. So are you going to bump up your STD into a family replacement and apply to the state to opt out of family with your private plan entirely? Or are you going to keep your STD while family's in place? And then what will be the coordination of those benefits? Because a lot of STD plans pay less than 100%. They might pay 60%, they might pay 80%. Well, if family's paying up to 90%, how is that gonna work? I would think you'd want to adjust it again so that you don't have a situation where an employee is getting, 170% of their pay between the STD plan and family. So I would think, look at that before 2024. Look at that now. Get in touch with your brokers and look at that now.
Okay. Is there a possibility that employers who offer private STD plans that comply with family will not have to start paying January 1st of 23? Are there any challenges to this?
Unfortunately, no, because that was the really bummer news that we got from CDLE most recently on family, because again, they're not ready to approve everybody's private plans. So they're going to make you start paying into that system, and then they're going to refund you the money. So I don't know of anything anything's possible, right? You guys have been in enough of these updates to know that sometimes I have to eat words that I've said months prior because the world changes. So anything's possible, but right now the CDLE is saying, even though you're going to have a private plan that you believe complies, you're going to still have to start paying 1/1/23.
All right. Is there any way for employers to channel that ruling?
Challenge that? Yeah. Well, this is the CDLE's position. So there probably are things that you could do to lobby the CDLE to certainly make your objection known to that. If you want to do that in a coordinated way, I believe that chambers are probably providing feedback. I know, and that may make a dent. I just can't promise that. I mean, there's also the route of litigation, but that's costly. And I'm not a litigator, so you'd want to talk to a firm about what they think prospects are to challenge that. There's been one challenge, right, to the constitutionality of family, and that went by the wayside, probably with some substantial cost for that business. But there's probably a way.
Thank you. And then can you put the link in the chat that takes them to the outline benefits employers need to provide beginning 1/1/23?
The outline benefits. I'm sorry.
Yeah, Charlie, can you clarify that question for us?
The family benefits? That you mean the announcement that CDLE made that you're going to need to, even if you've got a private plan, you're going to need to start paying in?
Yeah, the family benefits and contributions.
Okay. Yeah, let me make a note. I don't have that link right here, right now, but I'm going to be sending the slides, and Cece's going to be sending them out. So let me get you the link to that information.
Okay, I'll make sure to include that in the email too.
Okay. Yeah, I'm making a to-do list right now. We'll get it for you.
Thank you. Can you provide direction on where you can find exact language of family in handbooks? Do you have any
family language
example?
for a handbook?
Mm-hmm.
We have one in our handbook resources for our members. Let me check the family website and see if they have something in place yet, because I know they're putting more things out. So I'll put both of those links in.
I can pull out the family resources link too that you had in your slides and put that in the email for you guys. A lot of their updates will be on there. So as they come in with more resources, if we don't have them yet, you will be able to find them. Yeah,
exactly. They do have a resource page that has that poster. So let's see if they've got a policy yet.
Yeah. So we'll give you maybe one or two more minutes to type in any additional questions, because I see people are still on. But we are at a little standstill for now. Tina, I appreciate your time and input so much. I know this is like very helpful to our members, and
Good.
I think families always got a lot of questions, but on that resource page too with the webinars, looking at the questions that have been asked and answered is also very helpful, because those are hour-and-a-half long webinars that are dedicated just to family. So if you have questions, or as you're kind of sorting out what that'll look like, it may be helpful to look there. I want to thank our sponsors again. So the Employers Council, who does a lot of these with us, Northwest Data Services, and Mountain Valley Bank. And then if you guys don't have any further questions, so here we've got some more. Where are the webinars for family? Charlie, it was in one of the slides, but I will pull that link out and put it in the email with this like additional slides and stuff too. And will you put the slide that had the links for family resources? Yes, we will. So if that's it, I will just say thanks to everyone for joining. And then if you have any additional questions, you can send them to me as you come up with them, and I can work with Tina on maybe getting some of those answered. So have a great day, everyone. Thanks for joining us, Tina. We will see you again soon. Bye.
Thanks, everybody. Take care.